You're completely out of your constitutional rights.
How's that?
Well,
when you're telling me you weren't involved in the incident, and they tell me you were, and you try to walk away, we're going to put you in handcuffs.
Can I ask you something for real?
Yeah.
So I come in here for food, and I'm arrested.
You came in for food, it sounds like you dropped it out there. And when you came back and you threatened to beat his ass.
Because I shouldn't even be talking to you right now.
Okay. Don't you want to just go home? Because I'll just give you some paperwork and you'll go home.
No.
Okay.
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 Well, you're under arrest now.
On February 12, 2026, officers responded to an Arby's in Colorado after staff reported a customer spat on the counter and threatened an employee. This footage raises three distinct legal questions: whether the detention was valid, whether the obstruction charge survives statutory scrutiny, and whether the DUI charge is supported by probable cause.
How is that?
Evening, sir. What's your name?
I'm not going to answer that.
I was just asking to figure out what's going on. Are you involved in
Please
this?
step.
What's that?
Step.
Are you involved in this situation? Are you involved in this situation?
No.
Hey, where are you headed? Hey, you're not going anywhere yet.
Whoa.
Get over here. Get over here. Not allowed to leave. Not allowed to leave.
You're not allowed to.
Don't walk away.
Listen, dude, it's not going to go good for you. We're going to put you in handcuffs for right now.
For what?
We're figuring out what
We're figuring out what's going on.
your involvement is with this case.
What?
Yeah. You want to tell me now?
No.
Okay.
Is your car outside?
No.
That's not your car. How did you get here?
Don't worry about that.
Okay.
Again, we're fact-finding at this point?
So,
Yes.
you seem hostile. That's okay.
You're intoxicated.
Oh, am I?
Yeah, I could smell it on your breath.
Oh, okay.
And I can see that you're wobbling.
Alright.
Do you want to tell me what happened and your involvement in this or no?
Oh my god, dude. I came here to get food.
Okay.
The bag broke.
Okay.
And I asked them to remake the food.
Okay.
You want to arrest me? That's fine. It's okay.
But when you, yeah.
You're completely.
Sorry, Congress. Okay.
You're completely out of your constitutional rights.
How's that?
Well-
when you're telling me you weren't involved in the incident, and they tell me you were, and you try to walk away, we're going to put you in handcuffs.
That's fine. But that doesn't mean anything.
Right. That doesn't mean you're going to jail.
Right.
It doesn't mean you're going to jail.
Right.
Right now, it sounds like it's going to be a disorderly conduct, which is a piece of paper I'm going to give you right here on
You get a
scene.
court date.
Okay? You're going to get a court date.
That's fine.
Where's your ID at? That's a big part of this. You got to ID yourself, otherwise you will have to go with us. It's just part of the rules.
Can I ask you something for real?
Yeah.
So I come in here for food, and I'm arrested.
You came in for food, it sounds like you dropped it out there. And when you came back and you threatened to beat his ass, that's the problem.
Okay.
You can't do that. So that upset him. That alarmed and disturbed him.
So wait. Show me where I said that.
I'm going to believe him.
And why?
And because I believe that's the reason he
Sure,
called
so
us.
you'll have to prove that in court.
Exactly. We will go to court.
Great,
Yeah.
great.
So
do whatever the
I just need your ID so I can fill out a form for disorderly conduct. And then we will have a court date.
No, that's not going to happen.
You don't want to give me an ID?
No.
Okay. So then you'll be obstructing.
That's all right.
And then we have to go to the station,
That's okay.
and then we're going to have to identify you
You're
and do all
fine
that.
to do that, yeah.
You want us to do that?
Oh, absolutely.
You want to be you want an extra charge?
100%.
Oh, let me ask you this. Is there a reason you don't want to show me your ID?
Yes, ma'am.
Okay, what is your reasoning?
Because I shouldn't even be talking to you right now.
Okay. Don't you want to just go home? Because I'll just give you some paperwork and you'll go home.
No.
Okay.
Okay.
Well,
The initial stop is lawful under Terry versus Ohio, 1968. Officers possessed reasonable, articulable suspicion from multiple staff accounts alleging spitting and a verbal threat. The subject remained on the premises when officers arrived, and that factual basis satisfies the Terry threshold for an investigative detention. When the subject attempts to walk away, officers physically detain him under Illinois versus Wardlow, 2000. Movement away from officers during an active investigation contributes to reasonable articulable suspicion. Officers then demand identification, a procedure the Supreme Court addressed in Hiibel versus 6th Judicial District Court of Nevada, 2004. Hiibel upheld stop and identify statutes as constitutional during a lawful Terry stop, and Colorado recognizes a similar identification obligation during lawful detentions. However, Colorado lacks a standalone stop and identify statute equivalent to Nevada's, and that gap creates a legal vulnerability in the obstruction charge that follows. The subject's verbal refusal to identify is charged as obstruction under Colorado Revised Statutes Section 18-8104, and this is the central legal defect in this encounter. Subsection 1.5 of that same statute reads explicitly, "A person shall not be charged with obstruction because the person remained silent or stated verbal opposition to a government official. The subject used no physical force and created no physical obstacle. His refusal was entirely verbal, which the statute expressly protects. The obstruction charge, as applied here, is facially inconsistent with the law and is highly vulnerable to dismissal on a defense motion.
You're under arrest now.
Okay.
All right.
Well, you're gonna check your pockets, make sure you don't have anything in there.
I mean, why am I under arrest?
Disorderly conduct. And
For
now
what?
And now obstructing. Well, for what you said to
But
the
for
person behind it.
what?
Let me.
What is happening?
I'm gonna go
I
ask
came
for,
in for a
No,
fucking
John.
burger.
Why did you just say you were John? Why did you just tell us who you are and give us your ID?
You're not allowed to touch my wallet.
I sure am. You're in custody. That's how I identified you, because you refused to identify yourself.
Yeah, but you have to have a reason. For
Correct. You were involved in the disorderly conduct.
No.
No what?
No.
They literally just said that. And there's multiple witnesses.
But disorderly conduct would imply that I did something wrong.
Correct. And that's what they were
What
alleging.
did I do wrong?
Are you good with them for?
Yeah, but
Can
it
you
sounded
put
like
my personal property back in my pocket.
it's going to just hang out here for now.
And who says?
I do.
Because
We are still in the process of transporting you to the police station. If it's an option for you to get released, then we will release you. So we're kind of still figuring out what's going to happen to you.
do you care at all?
Do I care about what?
Humanity?
Yes, absolutely.
Okay.
Yeah.
Yeah, we have a disorderly conduct. We gone back to just.
Yeah,
citing
he's
him,
gonna
or
be
he's
gonna be
cool?
going.
The other thing we have to deal with is your car.
I don't have a car here.
That's not your car out there.
He's being pretty uncooperative again. So.
No, I'm being extremely cooperative.
So you have no issue with me turning that car off and locking it up and taking the keys.
Excuse me?
I think we'll just do that for now.
What am I being detained
Same.
for?
Same as those two. Spitting and threatening to beat him up.
Spitting?
Yeah, spitting on the counter.
What?
So yeah.
No. There is nothing even close to that.
I mean, there's
There's
a
nothing
battery,
even
man.
close to that. So
They
you
just
go.
went on the counter.
Okay.
No, it's not even true. So go
He
ahead.
was, he's starting to get fired up again and wants to talk to
Excuse me?
the sergeant. So
I do, but you have no clue what I've done, and I have not spit on that counter. So you can say whatever you want to say, but that is incorrect.
there's witnesses, man.
No, there isn't witnesses. You have not a leg to stand on.
Okay.
Nobody
We're
spit
not
on
gonna
that
do the
counter.
obstruction, we'll just do this.
Nobody spit on that counter.
It's up to you. I mean,
Nobody spit on
I
that
think.
counter.
I think.
Come on, prove it.
He's just,
No.
What are you, he's gonna walk home?
Spit on the counter.
What?
Who?
I'm not spitting on the counter.
Who spit on the counter?
They're alleging you did.
Well, fucking prove it. Prove it.
It's more likely than not at this point.
No, you don't understand.
Multiple witnesses.
No,
Yeah, I do understand.
multiple witnesses, nothing. You have to prove it. The burden of proof is on you.
That's in the courtroom.
No.
Yeah.
Well, okay, so you can do whatever the fuck you want. I've spent so many nights in jail.
Okay.
You want to give me another night in jail? But I will tell you right now. I will fight to the death. So if you think that you were going to manipulate me over something that I didn't do, I came in here to order food. I have not spit on their counter. And guess what? The manager of this location is my best friend. Okay. So if you think that he's going to trick me out and give you evidence unrightfully, you're wrong. He will 100% stand up for me. Okay. And he will provide the evidence, and you will be prosecuted for your false actions. So if you want, you can do whatever the you want to do. Okay. But I'm going to tell you right now, you're in the wrong.
Who's in the wrong?
You!
Me.
Yes!
For what?
I don't fucking know what your
Neither
problem
do
is.
I. Yeah, I don't know why I'm in the wrong either.
I don't know what your problem is, but I did not spit on this counter. I did not offend these employees.
I wasn't here. We have to go based on what we have.
Right, but what you're basing on is their opinion, not mine.
Independent witnesses too.
No, there isn't.
At this point.
No, you're wrong. So you
Could
can.
be.
It's fine.
Okay.
I don't care. I'll sleep in the cell for the night. I don't give a.
Okay.
But you're wrong, and when it comes out in court, you're gonna have to be held accountable.
Okay, fair enough.
Fair.
Yeah.
Mr. Jackson?
Yeah.
No, shake my hand.
No, we can do that later.
Oh, so you don't want to be a man? You don't want to be a man and shake my hand?
Shaking your hand.
Yeah,
You're in cuffs right now.
Shake my hand.
If you somehow get out of cuffs, then I'll shake your hand.
No,
when we're done
shake
with this.
my
No, I don't need to shake your hand.
Oh, okay. You're not a man now?
Yeah, that's what it is.
Yeah. You ain't gonna have any evidence. You're not gonna find me spitting, because I didn't.
We have multiple witnesses and a victim that are going to sign complaints.
Who?
People that called.
Who?
I don't know who they are.
Yeah. So
They're victims.
So the victim, you have no idea.
He is identified, and the witnesses are identified.
Yeah. Okay.
And you'll have your time to argue everything that you want in court. But at this point, that's where we're at. Like I explained to you like 30 minutes ago.
Got it. You got a sergeant on the way?
There's another unit coming here. I don't know who's coming.
So you're saying you're the top of the food chain?
Right now, yes. I am the
That's
sergeant
it.
of
There's
patrol.
nobody else.
Right now working, there's nobody above a sergeant.
Okay, well, I'll deal with whoever will come in eventually.
Sure.
All right.
And you can do that.
What are we gonna do with that car out there?
Whose car?
Your car.
Don't worry about my car.
I don't know, but what should we do with it? Because you drank too
Don't
much tonight.
worry about my car.
You can't drive it though.
Drive it?
Yeah.
But what? I've asked to be released and walk home. What do you mean, drive it?
Yeah, I just don't because I think you had too much to drink tonight,
I have.
and I just don't want you to get behind the wheel. That's all.
Who's getting behind the wheel?
I'm just saying, it's out there running.
Okay, here, unhandcuff me and I'll walk home.
Well, you're gonna get out handcuffed here shortly. I just gotta fill out some paperwork. I just don't want you to drive that car.
I'm not driving.
Okay.
I gotta be honest. I want to step back so I can see both of you personally. I'm not leaving anywhere. I'm not being combative. But I'm gonna say something that really matters. Is either one of you ready to hear it or no?
I'm kind of interested.
Okay. Am I not entitled to my own opinion?
No, you are. You absolutely are.
Right.
You absolutely are.
So I don't know what your relationship is. You could be f***ing this guy. Well, but maybe it's true, right? But is it not maybe
it's
true?
kind of a crude thing to go to right away.
No, but
why
let me ask you
would
something.
you say that?
Well, because you're defending him beyond logic. Could that not be the case?
Oh yeah, you are very
Hey!
imaginative.
Okay.
You
so maybe it's a fucking reality.
Sure.
Right. So f*** you, f*** him, and f*** you.
Sir, is there something else going on besides the booze today?
Your fucking mother.
Oh, okay.
The subject's profanity directed at officers does not change this analysis. Under City of Houston versus Hill, 1987. Offensive speech toward law enforcement is constitutionally protected unless it constitutes fighting words, imminently likely to provoke violence. None of the subject's language in this encounter meets that fighting words threshold. At approximately 12 minutes and 57 seconds, the subject tells officers he will make them kill him tonight, a statement requiring analysis under Virginia versus Black, 2003. Virginia versus Black defines a true threat as a statement communicating a serious expression of intent to commit violence against another person. Read in context emotional agitation, significant intoxication, in custody setting. The statement more closely resembles crisis ideation than a calculated threat against officers. Whether it meets the criminal threshold under Colorado Revised Statutes Section 18-3209, threatening a law enforcement officer is ultimately a question for the court. The DUI charge presents a separate evidentiary problem. Officers' documented odor of alcohol, unsteady gait, and the subject's own acknowledgement of drinking. Under Colorado Revised Statutes Section 42-41301, those observations establish reasonable suspicion to investigate, but no field sobriety test and no breath test appear in the available footage. A DUI conviction requires proof that the subject operated a motor vehicle while impaired and without chemical testing or a witnessed act of driving. The prosecution faces a significant gap at trial.
And just because your behavior is going up and down.
My behavior is not going up and down.
It is.
No.
Yeah,
no.
because you just wanted to give me a handshake, and then you just told me to f my mother. So
Yeah, I'll tell you to f your mother every fucking day.
okay, but then you wanted a handshake 5 minutes ago.
I tried.
Yeah.
But you denied it.
Do you see how your behavior is going up and down?
No.
Okay.
I tried, but you were a dick. So now I gotta be a dick.
I disagree with you, but okay.
He's gonna come with us, okay, for obstructing and for the disorderly conduct, okay?
You see what I'm saying?
How close is your car close by?
I'm right out here.
Okay.
You can come with me.
All right.
I'll talk with you the whole way down.
Officer
all right?
Nicholson will walk with
You
you
want to
out.
just walk with me?
What's happening?
They're saying you're in custody, okay? You're
Why?
in custody for disorderly and obstructing, okay?
Why?
Me and you can go over that.
Fine.
As soon as I know, you'll know,
His
all
property's
right?
right there too, if you want to grab it.
If you want to just grab it up.
Yep.
What offense? Sounds like disorderly conduct.
And then you refuse to identify yourself. So,
So that'd be
It's
obstructing
not.
identification.
It's not my job to identify.
well, when you are detained,
If you're
yes,
detained and under
Detained
section that you
for
committed
what?
a crime.
disorderly conduct.
Disorderly conduct.
How?
I don't know how because I wasn't here for it, but
So
so as soon as they let me know, I'll let you know. I know they
So
already...
they can arrest me with
All
no.
right, John, before you get in the car, I know they've already searched you. Do you have anything on you whatsoever that you wouldn't want to take to a jail or
Yeah.
holding facility?
Yeah.
What do you have on you?
I have $9,000 in my thigh pocket.
In your thigh pocket?
Yes, sir.
Which thigh is it?
Right thigh.
The right
Got a
thigh?
chunk
And
or
I
something.
want it documented because that my father gave me that because I'm going to purchase a truck tomorrow.
Yeah, we'll get it all documented. You'll get a property sheet. You'll sign it in, sign it out, everything like that.
Garcia,
Yes.
I want to say something to you.
So,
I love you. Nicholas, love you.
Hold on.
This Jackson guy is straight the f***ing devil.
okay.
Here, you need to listen
I
to what he's
understand.
saying. He's talking
So,
about your
I'm going
property.
to put this money straight back, okay? I haven't
Straight
even
back
opened
where?
it. In your
In your
pocket.
pocket.
Yeah.
And I'm going to zip it back
Yeah.
up. It's obviously it's a danger to me.
No.
But I want there to be no
But
confusion that your money has
listen,
been messed with.
does anyone have their body cameras on?
Everyone's
All
got
of
their
us
body
do.
camera.
All of you. I want to say something. Mrs. Garcia, I want
You
the
got
opportunity to say
2151
this.
at traffic stop, Kirk and
Mrs.
Legacy.
Garcia, you've been more than kind. What's your name, sir?
Nicholson.
Nicholson. Mr. Nicholson, you've been more than kind. This man,
Okay,
our
you gotta
Jackson,
sit. Yeah, but I have
is
to see
literally
in this,
the devil.
Okay, well, you don't have to talk to him anymore, okay?
Okay. Are you still on?
Hey!
No, I should.
I'm gonna turn off.
What's that, guys? You've violated my constitutional rights. I know my fucking rights. When a cop is out of pocket and I ask to talk to his supervisor, it's my fucking right.
You can talk to the supervisor all you want, but his supervisor is not here.
But it doesn't
They're
matter.
not going to call in a supervisor.
Oh, 100%.
No, they won't.
No, bro, you're wrong.
Now you can come in tomorrow if you feel.
So you don't agree at all. You don't know what I'm gonna do. I'm gonna figure around and I'm gonna get him on video. He's so worried about what that thinks. You know, I'm gonna make you kill me tonight. You hear me? Hey, do you fucking hear me? I'm gonna make you kill me tonight.
Why would you say something like that?
Don't fucking worry. Watch what happens when I get out of this fucking truck. I will expose this whole department and you all will go the down. I never met a more fucking corrupt motherfuckers than you. What a horrible, horrible fucking people you are. And you... Oh my god, dude.
Officer Jackson receives a C+. The initial stop was legally sound, force remained proportionate, and property documentation was handled professionally. However, applying an obstruction charge to a purely verbal identification, refusal directly contradicts Colorado Revised Statutes Section 18-8104, subsection 1.5. And that charging decision is the dominant factor in this grade. Officer Garcia receives a B+. Her de-escalation technique, under sustained verbal provocation, was exemplary, consistent with crisis intervention team training, and she offered the subject a practical resolution pathway at multiple points. The deduction reflects a failure to independently challenge the statutory basis of the obstruction charge when it was applied. Officer Nicholson receives an A-. His conduct was professional and measured throughout, and the subject commended him by name before entering the patrol vehicle, a meaningful indicator of effective interpersonal policing. The subject receives a C. He correctly invoked his right to silence, directed his defense to the courts, and made the legally astute decision to request on-camera documentation of $9,000 in cash before transport. Against that, walking away at the outset provided the lawful basis for the stop. His in-custody threatening statement introduced a viable criminal charge, and his refusal to identify converted a citation scenario into a custodial arrest. The subject had the legal knowledge alcohol cost him the execution. 3 takeaways from this encounter. First, verbal noncompliance is not obstruction in Colorado, and officers must know, subsection 1.5 of section 18-8104, before applying that charge to a subject who has only refused to speak. A charge that cannot survive a motion to dismiss weakens the credibility of the entire case. Second, DUI arrests without documented chemical testing or a witnessed act of vehicle operation create prosecutorial exposure. Observable indicators establish reasonable suspicion, but they do not independently prove guilt beyond a reasonable doubt. Third, for civilians, knowing your rights and exercising them effectively are 2 different skills. The right to remain silent is real, but the right to refuse identification during a lawful detention is not. Hiibel is settled law, and conflating these 2 rights, especially while intoxicated, produce the outcome seen here: 4 charges instead of 1. Let us know if there is an interaction or legal topic you would like us to cover in the comments below. Thank you for watching, And don't forget to subscribe to our channel for more content on police court interactions.